Welcome to the fourth video in our redundancy focus mini-series. I'm Charlotte Geesin, and during the course of this video I will be talking to you about appeals and unfair dismissal claims and redundancy termination arrangements and termination payments. When it comes to the matter of redundancy appeal, once the consultation selection process has ended and employees have been served with notice of redundancy, unlike other dismissals, such as those on grounds of disciplinary action or conduct, for example, it's actually unclear as to whether an employee must offer a redundant employee a right of appeal against their dismissal. There's a suite of case law on the point which generally accepts that there is no rule that a dismissal for redundancy will automatically be regarded as unfair on account of the absence of an appeal procedure. That said, probably only a very brave employer would take this line and not offer a redundant employee a right of appeal. An employee who is dismissed by way of redundancy can still claim unfair dismissal, and they can challenge their dismissal on grounds of both substantive fairness, i.e. on the basis that there was no redundancy situation in the first place and or that they shouldn't have been selected for redundancy, and also procedural fairness, which is basically anything to do with the selection, consultation, dismissal process. And it's this element of fairness where the matter of appeal comes in. When it comes to redundancy and unfair dismissal, then, the test ultimately remains that of fairness overall under Section 98(4) of the Employment Rights Act 1996, otherwise known as the reasonableness test. Therefore, whilst failing to offer an employee a right of appeal will not necessarily be fatal to fairness in every case, it may affect fairness depending on the facts of a particular case. It can, I suppose, be argued that if there's proper consultation prior to dismissal on grounds of redundancy, that ought to obviate the need for any appeal. However, we would certainly always suggest that employers do offer a right of appeal in any event, especially when there is a possibility that there may have been a defect in the earlier consultation process. The ACAS guide on handling small-scale redundancies, which, unlike the ACAS code on disciplinaries and grievances, has no statutory effect, also suggests that it would be good practice, at the very least, to offer an employee who is made redundant the right of appeal, since this can enable disputes to be resolved internally without recourse to employment tribunals if indeed the employee is disappointed or upset by the fact that they have been made redundant. Separate then to the matter of process, in a redundancy situation are the termination arrangements which will apply. For the most part, the termination arrangements relate to the matter of redundancy pay and notice pay. When an employee is dismissed by way of redundancy, they will probably be entitled to both of these things, notice pay and redundancy pay. But it is really important to remember that the two things, the two payments, are totally separate to one another and are not the same thing. Quite often I come across situations where employers consider the redundancy payment to be the only payment that's due, and often the notice payment or the notice entitlement is forgotten about. It's important to bear in mind that both are relevant on termination, because there will obviously be an additional cost to a business on termination on grounds of redundancy pay if both of them haven't been factored into calculations from the outset. Looking at notice and notice pay first. Notice of termination of employment can be an extremely complex area of employment law, and advice should always be sought whenever an employee is dismissed on grounds of redundancy to ensure that notice has been properly served and also that an employee's entitlement to notice and notice pay has been properly calculated. This video is not intended to focus on the ins and outs of notice and notice pay. That's probably a video series in itself. However, I will detail some of the key principles regarding notice, which do apply in a redundancy situation. When it comes to the actual giving of notice, so telling the employees that they have been dismissed and they are beginning their notice period, the requirement to actually do this is generally set out in an express term within an employee's contract of employment. And where this is the case, a failure to give an employee the required notice will most likely constitute a breach of contract. Where there is no written contract of employment or no express term dealing with notice of termination in any other written documentation, there will nevertheless be an implied term to give reasonable notice. The absence then of an express contractual term requiring the giving of notice, or of an express contractual term requiring notice of a specific period, do not mean that there is no requirement to give notice. So don't be lulled into a false sense of security if that's the case in any redundancy dismissals that you may be dealing with. Section 86 of the Employment Rights Act 1996 imposes a statutory obligation on an employer and an employee, actually, should they seek to resign, to give notice of termination. And this statutory obligation is known as the statutory minimum notice period. Where the contractual period of notice, so any notice stipulated in an employee's contract, exceeds that statutory minimum, then the contractual period will prevail. Likewise, any contractual terms specifying the procedure for given notice, for example, that the notice should be given in writing or that it has to be delivered to a certain person, will apply even though such requirements are absent from the statutory obligations concerning minimum notice periods. So again, when you are looking at terminating employees' employment on grounds of redundancy, do ensure that you check the contracts of employment and any associated policies that you may have for dealing with redundancies to ensure that you're acting in accordance with any contractual obligations that you may have. Although an employee cannot contract out of the right to receive statutory minimum notice, there isn't actually anything to prevent an employee or an employer, obviously, from waiving their right to receive due notice of termination on any occasion. This means that if an employee who is entitled by contract or by statute to receive notice of termination of a particular length, they may agree to accept a shorter period of notice or indeed no notice. That seems highly unlikely to me to be something that you're going to be able to get your employees to agree to in a sort of normal redundancy situation. However, if you're perhaps looking at notice which incorporates redundancy termination, which also incorporates perhaps a settlement agreement, it might be something that you can perhaps look at discussing at that point. In terms then of how much notice an employee who is made redundant must be given, ultimately this depends on whether an employee is entitled to contractual or statutory notice. Contractual notice, like I've said, is dictated by an employee's contract of employment, and the period of notice in this case is usually determined by what the employer and employee have agreed and recorded in writing, or in a sort of a verbal discussion, or a less sort of formal conversation, perhaps conducted via internal email. In any event, any contractual period of notice must always be equal to or greater than the statutory minimum notice periods, otherwise it won't be enforceable. If a contract of employment is not for a fixed term contracts, redundancy termination, notice payments are again a whole separate issue, and there is no express agreement as to the notice required to terminate the contract, then it may actually be terminated on reasonable notice. In a case like this, the court will not simply imply that the period of notice should be the statutory minimum, which I'll come on to, but it will actually seek to investigate the parties' contractual intentions and find out, on the particular facts of the case, the period of which reasonable notice actually is. In some cases, a period of reasonable notice might be the same length of the statutory minimum period of notice, but in others it might be far greater. The period of reasonable notice in each case, should it be something that the courts are looking to determine, will ultimately depend on the unique characteristics of the specific contract of employment. But generally speaking, in the event of a dispute, a court is likely to consider such matters as the typical notice period for the job in that industry, the notice period of any colleagues who have expressed contractual terms as to the notice period, who have also been made redundant, the employee's length of service, the employee's salary and seniority. A court ultimately is liable to make any determination as it sees fit based on the facts, but it is unusual to find a notice period longer than 1 year in a contract for an indefinite period. I think it's always really important, as far as possible, to clarify quite clearly the intentions with regards to any contractual notice period in writing with an employee, even if redundancy isn't contemplated at that particular point. In the event of a dispute, depending on the judge that you get on the day, a sympathetic one, like I've just said there, may actually find that you're liable for a massively increased notice liability, which you certainly wouldn't have accounted for at the outset of any redundancy consultation proceedings. Still on with contractual notice periods, it's open to an employer and employee to agree any period of contractual notice. But like I say, a court will not enforce any contractual notice that is shorter than the statutory minimum, unless either party has waived their rights to such notice. Therefore, for practical purposes, when you are discussing contractual notice with an employee, there's very little point in parties seeking to agree a contractual period of notice that is shorter than the statutory minimum, because it's unlikely to be enforceable. Where an employer and an employee agree a contractual period of notice that exceeds the statutory minimum, then the court will enforce the parties' contractual rights to that enhanced notice. In terms of statutory notice then, which is slightly different to contractual notice, when an employee has been continuously employed for 1 month or more, they are entitled to receive a minimum period of notice of termination of their employment from their employer. And that is provided for again by Section 86 of the Employment Rights Act. This is known as the statutory minimum notice period. And if the contract of employment provides for a longer period of notice, then, as I've said, the contractual notice will prevail over that statutory minimum notice period. Any contract which does not provide for notice periods, or which allows the contract to be terminated on shorter or no notice, is technically varied so that statutory notice period applies. What Section 86 effectively does is import the statutory provisions into the contract of employment, so that if the notice given by the employer is shorter than that statutory notice, then the employer will be in breach of contract, and the employee's action lies in breach of contract should they seek to resign, not in breach of the statutory rights. The statutory periods of notice are as follows. An employee who has been employed for more than 1 month but for less than 2 years is entitled to 1 week's notice of termination. Where an employee has been employed for more than 2 years but for less than 12, then they are entitled to 1 week's statutory notice for each year of continuous employment, up to a maximum of 12 weeks. So if you have an employee who has been with you for 10 years, they will be due 10 weeks notice. If you have an employee who has worked for you for 12 years, they will be entitled to 12 weeks notice. However, if you have an employee who has been employed with you for 13 years, or 14, or 15, or 20, or 25, or 30, they will only be entitled to a maximum of 12 weeks under the statutory notice scheme, because the cap is at 12 weeks. When we're looking at resignation, an employee is under a statutory obligation to give their employer of at least 1 week's notice that they will be leaving if they've been employed for 1 month or more. So obviously not entirely relevant in a redundancy situation, but it just sort of completes the picture. Once an employee's entitlement to notice has been established through looking at the statutory provisions and also any contractual provisions that may or may not apply, an employer then needs to determine how the employee will receive the benefit of that notice entitlement. Generally speaking, an employer has three options for effectuating notice of termination of employment. Firstly, they can allow the employee to work their notice period. In this circumstance, the employee will generally be paid as normal and be in receipt of normal benefits for the statutory or contractual notice period, and then they will receive a redundancy payment on termination, along with a payment for any accrued but untaken holiday pay and any other ancillary payments that may need making at that point. The second option is to place an employee on garden leave for the notice period. To place an employee on garden leave, an employer needs a contractual right to do that, or there needs to be some separate agreement between the parties. But ultimately, this approach would see an employee being paid as normal and receipt of usual benefits during the notice period, but with a limited requirement to actually work. Garden leave generally is implemented when you're looking at termination of your senior employees or employees like sales managers, sales assistants who really you don't want to be working for a competitor or anywhere else for as long as possible. Redundancy pay again is generally paid at the end of the garden leave period once the employment actually ends. The third option is to terminate an employee's immediately the employee's employment immediately with a payment in lieu of notice, and then a redundancy payment at the same time. This approach also requires a contractual right and or express agreement between the parties, and employers who terminate employees' employment with a payment in lieu of notice, but in the absence of an express right to do that, will technically be liable for all benefits, including holiday, that would have otherwise accrued during the would-be notice period. So watch out for that. If you have a contractual right to make a payment in lieu of notice, what your contract of employment should do is also carve out very clearly what benefits will not be included in that pylon. Ideally, you only want payment in lieu of notice to be based on basic salary. You don't want any bonuses, commissions, car benefits, anything like that to be payable. But like I say, you do need your contract to be very clear on that point. So again, something to just be mindful of. At the time of filming this video, there is also a fourth option, which allows eligible employers to leave eligible employees who've been redundant on furlough leave for their notice period. This allows the employer to then claim a portion of the notice pay back under the coronavirus job retention scheme. The furlough scheme is in place until the 31st of October, and at the minute there's sort of no current plans to extend that. So time is sort of running out, particularly for those employees who may have a longer notice period. And you should remember that it's also highly advisable to ensure that your employees receive 100% of their notice pay, even though they may be on furlough, to ensure that no further claims can come at the point of termination. So that's notice. When, like I say, an employee is made redundant, they're also entitled to a redundancy payment, or they may be entitled to a statutory redundancy payment, depending on how long they have been employed. Additionally, an employee who is made redundant may have an express or an implied contractual right to enhanced redundancy payment. In circumstances in which an employer is liable to pay an employee a statutory redundancy payment, if they either fail to make that payment because they're insolvent or they just refuse to do so, not advisable, the employee may apply to the Secretary of State for payment out of the National Insurance Fund. When it comes to statutory redundancy payments then, Section 135 of the Employment Rights Act states that employees with at least 2 years continuous employment at the relevant date are entitled to a statutory redundancy payment if they are dismissed by reason of redundancy. Statutory redundancy pay is calculated in accordance with a formula set out in section 162 of the Employment Rights Act, which is based on age, length of service, subject to a maximum of 20 years, and pay, subject to the applicable upper limit on a week's pay, which changes each year. The government actually runs an online redundancy pay calculator through its gov.uk website, which is brilliant, and it's extremely easy to use. And it ultimately calculates an employee's entitlement to statutory redundancy pay. So if you do want clarification as to how much redundancy pay an employee is due, then I'd suggest that you take a look at that calculator. In addition to a statutory redundancy payment, as I say, an employee may also be entitled to enhanced contractual redundancy payment. This entitlement may be either express or implied, and if the employee's contract of employment expressly sets out a redundancy policy, this policy will be an express term of employment. So watch out for that. However, it is more common for a redundancy policy to become expressly incorporated by being set out in another document, which is referred to in the employee's contract of employment. So again, just ensure that all of your internal policies are cohesive in this sense and adequately reflect your intentions regarding contractual redundancy pay. If there's no express entitlement to a contractual redundancy payment, there may be an implied entitlement to an enhanced redundancy payment. And the most common way in which redundancy terms may be implied into an employee's contract is where a set of redundancy terms are regularly applied in a particular organisation or within a particular department or with a certain level of staff by a particular employer, i.e. It becomes customary practice to do so. In this case, an employee may be able to show that there is an implied incorporation of the enhanced redundancy terms into their contracts of employment, even though it's not written down anywhere. In order to establish this, an employee must show that the custom in question is reasonable, notorious, and certain. This basically means that any policy's terms must be fair and not arbitrary, must generally be established, and must be well known and clear cut. So again, if you have a history of paying out an enhanced redundancy payment to certain groups of people or in certain situations, then do bear in mind that you may have set yourself a precedent which actually creates an implied contractual right for certain affected employees. Either way, in operating an enhanced redundancy payment scheme, an employer must ensure that it is really careful that the manner in which it applies enhancements will not leave it open to the accusation that it's a disadvantage to any employees over others in a manner that is discriminatory. Well, I hope that this video has been useful and that you're now very clear on the appeals process and the arrangements for termination when it comes to notice pay and redundancy pay. Join me for the 5th instalment of this series where I will be talking to you about collective consultation. Thank you.